This is Michelle coming live again to you. I had some technical difficulties like always, so who knows? It might be 5 videos today that I make that are separate. So I'm going to go ahead and continue on. Again, Judge Richard Posner, who was one of the Court of Appeals judges, along with the other 2 judges, Easterbrook and Mananian, or I hope I'm pronouncing that properly. They were the 3 judges that they actually dismissed and remanded. So that's the end of that's what Judge Richard Posner had wrote. So let's go ahead and continue on. He's asking questions.
That somehow caused a harm to a modern person.
Because the owner would not buy a slave and invest the money in buying the slave if someone wasn't willing to insure his investment. In the same way we insure our investments today.
Without insurance, there would be no slavery?
Without insurance, without loans upon slaves, without the vast financial apparatus that was used to support this institution.
There was extensive slavery in Greece without insurance.
I really hope Your Honor is not going to evaluate torts against American citizens by other American citizens by ancient Greece.
You just made a factual claim that without insurance there can be no slavery. And I was observing that appears not to be the case for most of the time in most places in the world.
Your Honor,
so why would you think it to be true in the American South in the 19th century?
Your Honor, the nature of American slavery was of a highly economically oriented business. Specie, hard currency, was rarely available in the American South. Credit was used to purchase slaves.
Even if that were true, no insurance industry, no slavery, you'd still have a great deal of difficulty connecting. I mean, in 1853, what law would Aetna have been violating by insuring slaves?
Your Honor, in every northern state where these financial companies were headquartered, and I would not say it's limited to insurance, the principal claim here is banking companies that loan money to buy slaves. In every northern state, Massachusetts, Rhode Island, New York, Pennsylvania, slavery was illegal, as was taking an interest in slaves. So, and the defense never objected to this contention in any substantive way, and Judge Norgel addressed in his opinion the fact that in many northern states slavery was illegal. So we have an issue of an apparently illegal activity in the states these banks were headquartered in. Now, Dean Prosser,
how would you show that if Aetna was violating the law and insuring slaves, how would you show that had caused some tangible injury to someone living today?
Your Honor, the issue is, I don't know what the white light means. My apologies, Your Honor. I don't know how much time.
One thing I want to point out, remember injury. Okay? So, and also, I don't know if you guys are familiar with Ta-Nehisi Coates. He is an author a black author from Baltimore, raised, that wrote a book, A Case for Reparations, and you can find quite a bit of information, and I'm going to be playing some of his responses to some of these questions a little on too in this podcast. So hey, stay with me. Also, please, if you're listening, go to our YouTube page, okay, and subscribe. And hit the bell so that you would get notifications when I go live talking about this subject matter. Thank you.
I have left. Don't worry about it. Thank you, Your Honor. The injury is several-fold. One, any deprivation of wages through slavery obviously prevents the slave from acquiring assets. Even if it's de minimis, it's still an injury to the descendant.
An ancestor of a living person had a higher income because he or she was not a slave but employed in some capacity. How would you ever show that because that person had or would have had a higher
Again,
income,
this is 7th Circuit Court of Appeals Slave Reparations case, 2006.
In some change in the wealth of a current person?
Your Honor, most of us who are parents expect to pass our wealth on to our children, whether that wealth is large or small.
Who were not slaves in the 1850s were not people who accumulated estates.
That's not true at all, Your Honor. There were many wealthy African Americans who were free. And there were West Africa, and I would point out, Your Honor.
Well, I know, but of course there's a. But are you prepared to show that the ancestor of the plaintiffs and the class members were in fact people who would have accumulated substantial estates, which would not have been dissipated over the last 150 years?
I am prepared to show that
a lot of people living today whose parents were wealthy in the 19th century and who have nothing.
Your Honor, I am prepared to show that slaves who would have been free would have acquired significant assets. There are many examples of African Americans who did. There are millions of Americans today who have inherited wealth from the homesteading era, which slaves were kept out of. I have a friend, for example, whose family owned mills prior to the Civil War, whose home and kids' tuition was paid by the proceeds of the sale of those mills in the 1890s. And I will be prepared to say in great detail that transgenerational wealth would have been transmitted to these individuals today. In addition, we are not far removed. Two of our plaintiffs are the children of pre-1865 slaves who live today. They have an undoubted interest in asserting the rights denied to their parents' estates. The non-disclosure until 2000, beginning in 2000, prevented the living freed slaves from bringing these actions. Now, if we had a chemical maker who knew he was marketing a dangerous chemical, knew it was causing injury to 2-3 generations of workers, then discloses and makes his mea culpa only after the last of the workers are dead, would we immunize that company from suits by the descendant? We would not. We need to begin to realize this is a great massive tort created by these banks that finance the slavery of the ancestors and the parent of my clients. This is not ancient history. This is living history. And had these banks made their disclosures in the 1920s, the 1930s, the 1940s, there would have been hundreds and at times thousands of living plaintiffs who were slaves who could have brought this action. Do we reward these defendants for their non-disclosure?
But are you saying that if these defendants had not violated any laws in the 1850s or so, there wouldn't have been slavery?
Slavery was materially advanced by the capital forwarded.
I think it's kind of funny how this Judge Richard Posner, the way he words everything, it's really kind of manipulative, his wording, in the questions that he asks all of these attorneys. He's giving such doubt to why already these reparations cannot be made. Okay? Point out Posner is a Jewish name, and as we know, the reason why we cannot get our reparations is because the people that owe us the reparations, the head of all these companies, J.P. Morgan Chase, all these big American companies are owned by Jews. White Jews, okay? The people that are accountable for us getting our slave reparations are the same people that are running America. And that is the problem here. And we have got to make the case for the reparations. And I will go over that with you all after we get done, after I want you to hear what had happened in 2006. So I'm going to go ahead and let this play.
Those who loan money to the master to buy slaves. Would there have been slavery? Of course.
But was it enabled? Because now you're saying, well, maybe there would have been less slavery.
I will answer that question. We can't say there would have been no slavery. I would never suggest that. But obviously, if a joint tortfeasor materially contributes to the maintenance of an institution, he bears a substantive degree of liability. We're asking to measure his liability by the profits he made from those actions. That's an inherently reasonable fit.
How could you possibly determine what profits Aetna made from insuring slaves?
Well, it's not only Aetna, Your Honor. I think that's not the strongest area to focus upon. The banks, for example, that bought slaves and financed them, J.P. Morgan Chase, has disclosed in 2005 that it had liens on 13,000 slaves and owned 1,200 outright. We can calculate almost precisely, to eliminate virtually any reasonable degree of speculation, the profits earned from those slaves and what the present value would be today. The average sale price of an adult slave was $2,500. The 1,200 slaves owned outright by J.P. Morgan Chase would have had
$2,500. Unbelievable. They literally put a price tag on a human being and sold it on the U.S. stock market. That's literally what this country did. And we can't get our reparations? We definitely, America needs to pay the reparations. Now, whether or not you were not, and I'm talking to America now, okay? I'm talking to everybody that claims to be an American except ADOS. Whether or not you were not a part of what happened from 1619, okay, all the way up for 250 years, whether or not you had no role to play in that, you're still an American today. So America has to be accountable for what my ancestors endured. And that is the injury here. And this guy, Judge Posner at this time, if you listen to this, because we need to wake up, all of us black people, and come on cold and work together. And we need to have many discussions about this on every platform possible, because this is a very serious subject that we need to talk about in this country. If this country can give reparations, I'm going to even say worldwide, there have been several groups that have gotten their reparations. But what our problem is that we need to lobby. We need to have many cases going on all over the United States, especially in those states where there was slavery. And we need to do more advertising and positive propaganda on the subject matter, because this is a serious thing. And what happens is we often, and I'm seeing it right now happening in the YouTube community. Like I said, I was on a panel yesterday, and we really couldn't get anything resolved because of the fact of the divisiveness that we have in our community. The attacking, the negative attention, our energy, all the attention is so negative amongst a lot of us in the Black conscious community. And so there's a lot of issues. I don't mean to digress, but I'm going to go ahead and let Bruce Safran.
At a present value today of a minimum of $850 million. Based on the actual market value, I hate to use that phrase, of $1.7 million in 1865. And we can calculate the profits made by the loans to slaves by the percent of capital advanced by the prevailing interest rates in those days.
Correct, because obviously if J.P. Morgan, I don't think he was in business in the 1850s.
Chase was wrong.
Pardon?
Well,
whatever, his predecessor, whatever. If this firm had not financed slaves, they would have financed something else. Now, maybe it would have been less profitable, But how could you possibly compute how much less profitable it would have been to finance sharecroppers?
I understand Your Honor's economic focus, but I would suggest that this is very much an issue of fact.
This
and
is what our
we don't reward a
court system
simply because he could have invested in honest
looks
work.
like in this country.
The problem with calling it an issue of fact, the courts have.
He just got off the bench in 2017.
And
now I think he's a professor in the University of Chicago or somewhere.
Try to figure out.
His name is Richard Posner.
What the Morgan predecessors' economic and commercial alternatives would have been if they had decided not to finance slaves.
Your Honor, I can't believe that the legal position would be determined by the fact that the wrongdoer who violates the criminal statutes of his own state, causing a tort on innocent people, is free from liability simply because he could have invested in honest work. The fact that he chose to divert his capital to a criminal act, causing untold injury to people, creates his liability. It does not matter what he might have made and what differential would have existed in honest labor.
No, because if Morgan hadn't financed slaves, someone else who's not a defendant would have, right?
Morgan is the one that did it. It doesn't matter that some other bank chose not to.
It doesn't matter in the sense that if the only significance of Morgan's conduct is that some other company financed sharecroppers and Morgan financed slaves, then if Morgan had made a different decision, there would have been no consequences for your clients. Just some other company would have done the slave financing.
Your Honor, that's like suggesting that if one man robbed a bank, he need not pay back what he stole because someone else would have done it anyway. That makes no sense at all.
No, that's not true because
it seems a direct import of Your Honor's analysis.
That supply of bank robbers, but what is true is
I think the FBI has a grand total of banks.
If there are commercial opportunities, we expect firms to exploit them.
Your Honor, if the bank chose to advance its commercial opportunity through crime and tort, it needs to be redressed. It does not matter that it might, in a more fit moment of conscience, chosen to do otherwise.
Calculate the amount with some reasonable objectivity, then it just is beyond the judicial power.
Well, we don't know that, do we? Because we had.
That's the standing.
Your Honor, we can't determine that unless we have a hearing at the district court to see what standards can be used.
All they're trying to get is a hearing. They can't even get a hearing. It's like they're just going to shut it down, and they have shut it down. And that's how come it's not. But, that doesn't make us stop working towards trying to get it. Because defeatism is not an option here. And we got to continue to fight for the reparations. Now, I know this country's in debt. I know this country is not as rich as it claims it is. However, hell, if you got all that money, whatever, I know it's just a lot of paper, okay? Because these same people, they're really good in finance, and they use derivatives. They're really good in banking. So, hey, wherever you got to get the money, if you can build a wall, hey, you can pay us our reparations. That's how I see it.
In those cases, in the tobacco cases, hearings were held to determine the manageability. They weren't thrown out ever on a motion to dismiss without conversion.
Manageability is the issue of standing.
The issue of standing. No, Your Honor's asking how we would
Japanese can get $20,000.
How you would show there had been an injury.
We can show our clients are entitled to project what they're like.
And I know that's been some time ago.
But they're asking for less than that.
The Native Indians, so-called, who are not the real, of course, we know Native Indians, the ones that are benefiting from those treaties.
Then the present generation stand in the shoes necessarily of their ancestors. And so there's no need to prove direct injury to that present generation because equitable tolling would mandate that some would be permitted to go forward because the delay by the defendants prejudiced the right of the original victims to move ahead with the action. So if we accept equitable tolling, we've had no hearing to determine whether it ought to be. Your Honor's questions are fact pregnant. We need a hearing to discuss that. If we accept that equitable tolling could have occurred, then we know the standing issue is largely resolved because those in life today are standing in the shoes of those who were denied the opportunity to proceed earlier. And at every point in the 20th century, since the inception of numerous disclosure requirements, the banks ought to have made disclosure of these actions, or at least it can be argued quite credibly. And if they had done so, the living slaves would have had the information then in their lives to bring these actions. If equitable tolling is to be held, then it follows inevitably that those in life today must bring the action, or equitable tolling would have no purpose. So we need a hearing to determine a basis for equitable tolling. In the Alexander case, that's precisely what happened. The court said 1982 is the cutoff for tolling. Well, they had a hearing to determine that. All of these questions the court has put to us are the questions we've reviewed, but they're all fact pregnant. They're all fact laden. To discuss this on a motion to dismiss is simply improper procedurally.
Okay, thank you, Mr. Wareham. Mr. Ratcliffe?
Thank you, Your Honor.
Honor, we stand on our
okay. Now this
brief
is Sister
and just want to point out some new
Barbara Ratliff. Okay, this is a powerful sister, and I want you to listen to her. She is awesome, and she's got a book, and I'm going to show you guys. I think it's called Battered Race Syndrome, and she's out of Los Angeles. She's in the LA area. Again, this is 2006.
With respect to the California case, the primary issue is that the lower court dismissed the case without even discussing the issues in the California case, and we had issues. We brought our case based on some California statutes. This is the Hurdle case, right? And two of those statutes had to deal with standing and statute of limitations. And one of those cases, I put it out in the footnote in our brief, footnote 8, was that since we filed our lawsuit September 2002, in November 2004, California voters voted for Proposition 64 that amended the California Business and Professions Code sections 17, 200, 203, 204, on which we were basing our standing. And basically that statute said that an individual could basically act as a private attorney general and bring a lawsuit against a corporation or business for disgorgement of profits that were obtained unfairly or illegally without having to show direct injury. Well, the law has changed, and I'd like an opportunity to submit a brief on the cases because we haven't had an opportunity to do this. One of the cases, Californians for Disability Rights versus Mervyn's, there was a motion for rehearing denied August 30th. So one thing I also noticed in reading those cases was that they did not deal with the conflict between retroactivity of Proposition 64 and specific provisions in the California Constitution that provides that a referendum becomes effective the day after the election. So that wasn't dealt with, and that's a constitutional issue. So we'd like an opportunity to brief that. In the event that the court does not remand this case to the state court, which I think should be done, and that is our request, then we would like to amend our complaint so that we can allege that the plaintiff has standing independent of the statute 17-203-204. The other thing that I'd like to really emphasize is that I see us playing these legal gymnastics here, and what we'd like for the court to do is to use your power, use your influence to address this very serious issue that has never been dealt with. Here we are, first we were told slavery was legal. Now here we are being told that the types of things that we're trying to do have been barred, so it's illegal. We don't make these laws. And we know that what has happened to us has affected us not only economically, but it has affected us psychologically, emotionally. We have not even been prepared to bring these lawsuits. We're just getting to the point where we could even do this. And in the Garamendi case, I don't know if I cited it in this brief, but it certainly was cited in the lower court. President Clinton used his power as President of the United States in the year 2000 to negotiate a settlement in the Jewish slave laborer cases. And as a result of his coming in there and doing this treaty with Gerard Schroeder, they ended up with a humanitarian fund that was funded to the tune of about $6.2 billion. That had over 6,000 corporations in Europe participating. The United States pledged $29 million to the fund.
Did you hear that?
And many of the corporate.
Did you hear that? Okay? So this was for Jewish reparations. You had Bill Clinton, who helped in 2000, and we can't get our reparations. Even America put in $29 million.
Corporations that participated were not even involved in the Holocaust or came into existence in the 1950s after World War II. And what we need here is a spirit of motivation. And this court, I've been led to believe that this court has the power to have a settlement conference. You can bring in CEOs of these corporations, and you can use your influence to motivate not just these people, but you can bring in other companies, you can bring in experts, and you can be the beginning. It only takes one or two people who can decide to do what has not been done. There has not been any reconstruction for freed slaves for a sustained amount of time since 1865. And it begins with you. Why do we get all this education if we're not going to use our influence? And this, I think, is the most important case ever. Thank you.
She was
Thank you,
awesome.
Ms. Rasler. So
Now he gets all mad. Listen, Richard Posner, judge.
In a courtroom. That's very improper behavior, and you'll all be expelled if you keep on doing it. You understand? We have our own rules.
He
So,
got
Mr.
upset.
You can have 10 days to submit the supplemental materials you want.
That was such a powerful speech that attorney Barbara Ratliff gave, okay? And it was just such passion in her delivery when she gave that. And so my thing is, my people, don't think just because you have a racist Richard Posner judge, and I am going to prove to you that this man is racist, okay? He has written racist blogs after this period of time of him making this decision and his actions. You could tell he was biased in his questioning just so far if you're listening. It's very biased. And as she called it, gymnastics. Okay?
On those cases. Thank you. Mr. Meyer? Mr. Mayor? Oh, I had a fourth counsel list. Is there another? Oh, okay. Thank you. Then I'm sorry. Then we'll hear from Mr. Maddens.
May it please the court, Alan Maddens for the defendants. I'd like to address the issues of standing and the statute of limitations, both of which the defendants posit were appropriate bases, necessary bases for dismissal of these cases. With respect to the standing doctrine, standing is premised at bottom on the notion of separation of powers, which I think is an important concept based on the arguments that we've just been hearing. The importance to society, the importance politically of an issue does not excuse standing requirements, which are quite clear. To the contrary, if anything, the political and societal importance of issues dealing with slavery only fit right into the reasons why there is no standing, as well as some of the issues that Mr. Pell will be discussing next. The plaintiffs had a burden to show that there was standing. The plaintiffs had a burden to show that there was a concrete, non-speculative injury. The plaintiffs had the burden to show that that distinct and palpable injury was fairly traceable to the actions of these defendants, their injury, these defendants. And the plaintiffs had the burden to show that the injury traceable to these defendants could be properly redressed by the exercise of the judicial power.
This is Alan Madans. He's the attorney arguing against slave reparations. He's on the same. So there were several attorneys that went in front of the Court of Appeals for some questioning for a hearing that they didn't
for
get.
many of the reasons that Judge Posner was already describing. The plaintiffs, one of the principal ways in which the plaintiffs try to get past the concrete injury requirement is to show that they are standing in the shoes of their ancestors. That involves necessary speculation that had their ancestors been paid for their labor, that those monies would have in fact not been spent, but rather would have been passed on, and would have been passed on to these particular plaintiffs who allege in a couple of cases that they are seeking or have sought or might seek to actually be the heir, be the personal representative or executor of someone's estate, but nobody actually alleges that they are, nor is it plausible to think that somebody at this late date could attain that status. Now, even if the plaintiffs could demonstrate that it was likely that they would have inherited, even that is not sufficient, because the likelihood or expectation of inheriting from someone is the kind of injury that's been called a bare expectancy of no legal significance in cases that we cite. Then the plaintiffs argue that as consumers, they've suffered some kind of cognizable injury, but they don't and can't allege that the defendants had any obligation to provide the information that they're now saying was not provided. And the consumer protection laws that have been asserted here, they have nothing to do with complaining about a company's historical practices. They have to do with the sales of products and services and people who are injured because of that. If the plaintiffs choose not to deal with these defendants, that's their right. With respect to the fairly traceable...
All right, I want to point out one thing here.
The plaintiffs needed to allege, need to be prepared to show that their injury is the result.
About this Judge Richard Posner, who no longer sits on the Court of Appeals, but he sat on there quite a long time. This was, again, 2006 decision that was written, and it is now 2019, and he sat on the court. I mean, he just got off in 2017. Okay. Another thing that happened in 2017, I see we've had many people come to the forefront to work towards reparations. Just because we haven't gotten them now, people, there's no reason to think that we can't get them. So this movement with the ADOS, this has got to remain strong. As I said, we need 3 things right now to happen. We need Black lobbyists. We need Black attorneys. We need advertising of all sorts, positive propaganda on many different levels to keep the awareness. We need to have conversations about this. Okay? So one thing I want to point out here before I digress is I'm going to read this about Posner. His views on race and public education policy are informed by his view that groups of students differ in intellectual ability, and therefore that it is faulty to impose uniform educational standards on schools. His views, okay. I don't care about the school part. When you read down here, I find In a blog post, Posner wrote, I suggest that the only worthwhile reforms of teacher compensation are raising teacher wages uniformly, providing recognition and modest bonuses for outstanding teachers, and increasing hiring standards in the same post. Okay? In the same post, he wrote, I am not clear what we should think the problem of American education below the college level is. He says, I lost my place here. IQ, okay. So he goes on about IQ. He wrote, I am not clear what we should think the problem of American education below the college level is. Most children of middle-class Americans are white or Asian, okay? And I can't believe he wrote this. American education below the college is most of the middle class Americans are white or Asian and attend good public and private schools. Usually they're predominantly white. The average white IQ is, of course, 100, and the Asian, like the Jewish, okay, almost one standard deviation higher. That is 115. So you dig how that's written? The average black IQ is 85, a full standard deviation below the white average. And the average Hispanic IQ has been estimated recently at 89. So they're trying to say that their IQ is higher than ours. Of course, these kind of standard tests that they give, we know, have been biased against black people. They were made and designed just for them to say this. And we know that the white supremacists, they use this. Okay? This is what's used for them to make themselves look like they're smarter than we are. But we know that we are smart people. Okay? So this is nothing but a white supremacist tactic when they use IQ. Because we know that it's been proven that IQ tests are biased. And we know that this Judge Posner is biased. And the fact that he would write some type of blog like this shows that he has white supremacist views. Who knows what his past is? I don't know. I didn't investigate him. I'm just going off of what I'm listening to in this audio by C-SPAN of the actual hearing, not the hearing, but questioning. They were trying to get a hearing, which it was later on in his decision here. Oops. Now it's asking me if I want to restore. I was trying to get it to go before. Okay, so I just want to show you this. At the end of any decision, Posner wrote this. He's the one that's very biased in the questioning here. A little agitated now, as we can hear in the audio. Modified and affirmed, in part reversed, in part remanded. I'm just going to read the end of this. It's very long. To summarize, the district court's dismissal for want of standing of all but the claims brought by legal representatives of slaves plus the consumer protection claims is modified to be a dismissal without prejudice. I mean, he went so far to say it didn't even have any prejudice. And in prejudice means, in legal terms, any bias, basically. And as so modified is affirmed. Barbara's suit is dismissed, also without prejudice for want of diversity. The dismissal of the claims brought by the plaintiffs who claim to be illegal representatives is affirmed. Okay? So, that means that it was dismissed. But on the merits, statute of limitations, and so with prejudice. So he's, okay? The dismissal of the consumer protection claims is reversed, and the case remanded to the district court for further proceedings on those claims consistent with this opinion. Now, I have reached out to attorney Barbara Ratliff. Hopefully, I can interview her for this on my podcast here. And also, I put a call out to attorney Roger Warham because I like to see, what's going on with all of this now and what they're working on as well. So hopefully they will reach back out to me. So the district court is authorized to retain those claims for the duration of the litigation, except in the case of hurdle plaintiffs, blah, blah, blah. So that's in another proceeding. Okay. So basically, it was reversed in part. It was modified and affirmed. First decision. In part, reversed part, and remanded. And the only part that was remanded was the part that had to do with the protection consumer claims, which I don't know anything about. Okay? So they didn't get their hearing, and none of it went through with the plaintiffs. And I'm going to just let this continue on here. Now,
So
this again was written afterwards.
Not
the
the result
decision.
of actions by others, either instead of or in addition. But most important, there's no linkage alleged in these complaints between anything that these defendants purportedly did and any harm that was suffered specifically by these plaintiffs or even their ancestors. Prior slavery reparations cases have also founded on this element of the standing analysis. There are also, in addition to these constitutionally imposed standing elements that I've been discussing, certain prudential standing considerations as well at this court and all federal courts.
Curious about this is the status of heirs. We don't usually think of heirs as victims, right?
That's correct, Your
Heirs
Honor.
are people who may be able to sue as the representative. I mean, sometimes wrongful death, some states the heirs lose support, but generally, the victims would be the people who were slaves, right?
Those are certainly the persons with the injuries. The heirs, Your Honor, in most states, I think all states, do not have the right to sue as such. In Illinois, for example, the McGill case that's cited says that you have to be the executor or an administrator. You have to be appointed in order to represent an estate. In a wrongful death context, what you're talking about is individuals who claim that they have suffered a loss of support. They have their own injury.
Yeah,
So as you know, attorneys, oftentimes, that's why when you look at read these court rulings, okay, you often see that they have all the comments in regard to other cases, like in this one, Pacific States Telephone and Telegraph Company versus Oregon, 223. They put the statute and all that stuff in there, right? And that's basically what he's talking about right now, is that he's talking about other cases. And it's like you got to go through all this mumbo-jumbo bullshit, See, the court systems is a bunch of crap. We know that. We know that the justice system is a bunch of bullcrap. There was one point in time in my life when I wanted to be an attorney. But then when I got in college and I saw what I would have to do, who I would have to work with, I said it's not for me. Okay? So, again, I'm going to let this go on, but it's a bunch of bull crap, and I'm just going to let you listen to it.
So
Now, one of the prudential standing issues, of course, is whether the plaintiffs are asserting a generalized grievance that's more suitable to the representative branches. Mr. Pell will discuss that in a couple of minutes on political question.
what about the plaintiffs that were enslaved in the 20th century? Now, that's a lot more recent, right? So
there are two plaintiffs, the Wall plaintiffs, and I believe Ms. Clark, who alleged that they were enslaved in plantations in Louisiana, I believe, in the case of Ms. Clark. There is simply no allegation that these defendants had anything at all to do with that enslavement or with anything else dealing with it. The allegation as to Mr. Wall is that the defendants did business in some of the same states in which goods that Mr. Wall's labor helped to produce were shipped. That is not an injury that's fairly traceable to these defendants for standing purposes, and that's their best case. With respect to the statute of limitations, I'm not sure if the white light is telling me that I'm eating into Mr. Pell's time yet, but
go ahead.
On statute of limitations, courts have routinely dismissed reparations cases on limitations grounds. That includes the Alexander case dealing with the city of Tulsa race riots in the 1920s. It includes the more recent Holocaust reparations cases. Those cases, to the extent that they've generated payments to Holocaust victims, that has occurred through the political process, as Ms. Ratliff explained, with respect to President Clinton, and with respect to slavery, which is obviously the most distant of the reparations scenarios. There have been cases which go back to the mid-1990s, which dismiss slavery reparations cases on, among other things, limitations grounds. And since the maximum statute of limitations here was 6 years, and it was more
This is
than
Alan
6 years
Maddens.
between
He's the attorney arguing against slavery reparations. Again, this is a team of attorneys.
These cases were filed. It's a very simple analysis. The equitable tolling argument, and in the Seventh Circuit, and I think Your Honor, Judge Posner wrote the Singletary case, for example, one has to plead and then be able to demonstrate equitable tolling facts. There are 366 paragraphs in the second amended and consolidated complaint after Judge Norgal had given the plaintiffs an opportunity in dismissing their first amendment to amend and to assert equitable tolling and to otherwise salvage their claims. And there's not one paragraph of those 366 that says anything about what kind of reasonable diligence these plaintiffs and their ancestors used from the 1860s forward to know that these that these defending companies were involved in the slave-based economy. Just one point on what Ms. Ratliff said. I know it hasn't been cited, but since she's gone ahead and mentioned it, I thought I should explain. The Mervyn's case out of California was one that held that Proposition 64 does apply to require actual injury in order to assert a claim under the California statutes that are the basis of the Hurdle claim, even where those claims predated Proposition 64.
Does the Hurdle claim, does that really belong here? Why was that consolidated with the other?
Well, first of all, Your Honor, as you'll see in Judge Norgal's second opinion, he did discuss and dismiss both on limitations and failure to state a claim grounds the California statutory claim, which is also featured in the second amended complaint.
Should the case have been transferred here?
No, Your Honor. The case was properly removed on diversity grounds.
In California?
Right. It was removed from the California State Court to the California District Court and then brought here.
But should it have been transferred? That is, should it have been consolidated with these other cases?
Yes, Your Honor. I don't think that there's any argument that I recall, at least, that it shouldn't have been transferred. There are claims about remand.
The brief says no, that it wasn't a proper
Well, it clearly
tag-along case.
It clearly raises the same questions, albeit California being a different state than was raised in many of the other cases. But the Second Amended Consolidated Complaint also asserts the very same claim that the Hurdles claim. It's a slavery reparations claim, and we believe it was properly MDL'd.
Does that amended complaint mention the California law?
Yes, the Hurdles didn't join in the Second Amended Consolidated Complaint, but the other plaintiffs there did reference that statute, and Judge Nordel discussed it.
Okay.
Before you sit down, let me follow that up a little more. Was there any objection made in the district court based on lexicon to the district court resolving these transferred cases on the merits?
I'm not aware of any objection made based on lexicon. Actually, it would be our position.
The Supreme Court has said that after pretrial proceedings are over, the cases have to be transferred back to their originating districts. So I don't understand why they were resolved on the merits in Northern Illinois. Now, it may be that argument has been forfeited. There's no mention of lexicon in any of the appellant's briefs.
Correct. That would be our position, Your Honor, but I think that Judge Nordel, in finding that these cases were barred by standing, political question, and limitations after failure to state a claim, that was the end of the game in terms of pretrial proceedings. So we don't think he needed to transfer when there was a final judgment to be entered based on the proceedings that he was properly engaged in.
It's hard to see the entry of final judgment on a case as a form of pretrial proceeding, but since the argument isn't being made by the appellants, we needn't pursue it.
Thank you,
Mr. Madden. Mr. Pell?
Thank you, Your Honor. And please, the court. I was going to address briefly the political question issues and the failure to state a claim issues, although I think what Mr. Madden has said fairly deals with those. The district court did correctly dismiss these actions as non-justiciable. The district court did correctly recognize that the issue of slavery reparations was committed to the political branches because it was inherently...
That wouldn't apply to the people who were enslaved in the 20th century, right?
Oh, I think it would.
Oh.
I think it would for the same reasons, Your Honor. The people in the 20th century...
It's one thing to say, the Emancipation and so on, 14th Amendment, 13th Amendment, and so forth, brought about some fundamental change in society and so forth. But, there are cases involving illegal immigrants and so on where you have people being enslaved. The courts can certainly deal with issues like that without any strain.
Well, what the courts can deal with, Your Honor, is that there are already laws on the books. The courts don't have to create remedies in place of the political branches. The courts already have remedies that the political branches have created by way of civil rights legislation, by way of...
If you enslave someone today,
that's a crime.
It's false imprisonment and theft of services. It's all sorts of criminal and tortious activity, and someone can bring a case, regular civil case. There's no political question issue there.
Maybe I'm misunderstanding the question, Your Honor. The only political question would be is if you tried to assert a remedy that otherwise didn't exist in the rubric, in the panoply you just laid out. If you tried to bring a claim against someone who had not committed any of those acts, who had not falsely imprisoned, who had not taken labor themselves, if you tried to expand beyond the law.
State common law, you can certainly create new remedies.
You can attempt to. But I would generally agree that the remedies that already are there are available. If the courts want to use those remedies to fashion new remedies, that might also work without raising a political question under Baker versus Carr. But certainly the claim for labor conferred prior...
New York State wanted to punish Brown Brothers for having financed slavery and created a civil action against, companies that had financed slavery in the 19th century. And it's a diversity suit, gets removed into federal court, but the only issue is state law. Why would there be any political questions?
I'm not sure it would necessarily be a political question.
Most of their claims are state law claims.
Yes, Your Honor, and always have been, other than
All
the
right,
1982
enough
claim.
of him. Enough of that. Okay, as you can see, Posner was very biased. Now, I don't know what's happened since then, okay? As I said, this is part 1 of a series of videos that I'm going to be doing talking about the case for reparations. Basically, you know, we deserve to get our reparations. And if anybody out there that is ADOS that does not believe that, I wish you would just go sit down somewhere. You know, we don't need to have any negative affirmations or any power given, any juice, okay? You know, I just get so sick of all these black YouTubers who are just so negative. Okay, it's good to have critical questions, critical thought, and critical thinking. But when it becomes an everyday episode on your channel, and when you're talking about subject matter that you don't even know about, you haven't even cared to even do the research, or you don't even care to share with your audience the truth on a subject. But when it comes to this right here, this is some serious stuff right here, people. Okay? And what we need are black lobbyists. I know you've read this, but I'm just going to reiterate what this says here. This is how we can get our reparations. And it takes a movement like we're seeing right now, starting to happen again. And we've gone through this before and over, but we stop. We stop and we stop thinking and we don't stay focused. We have to stay focused. We have to have a strong movement, and we've got to support the movement. Okay? So, the movement is this. Again, this is my perspective. And, you know, I'm encouraging a think tank here. I want to put together a group of people that are interested in coming together. If you're looking at this, listening to it, you're seeing this hearing this on Facebook or either Twitter, okay, because we do a multi-stream. I do a multi-stream. Or if you're looking at this on YouTube and you want to get involved, I encourage you to contact me. You can contact me either by Facebook. You can contact me by emailing me at membership@bobrewards.club. You can also go to the website to find that out. Or you can call me at 888-665-5955. Option 1, hit that twice and you'll get me. Okay? So, I want, and I have the resource now to help in this movement. I can't do it all by myself. Yvette Carnell can't do it all by herself. Antonio Moore can't do it all by himself. And all the people that are in the BlackTube YouTuber community that are being vocal about this, and all the people, all the attorneys that have put time already and kind of feel defeatism, which I don't want to see us ever have any type of defeatism, feeling that way. Okay? So, again, this is what I think we need. We need the lobbyists, we need the attorneys, we need comprehensive marketing and advertising. We do have some resources, my people. Don't think we've been defeated, because that's what I've been listening to in podcasts all weekend long. And I'm sick of it. Just tired of it. Fundraising. We have to have fundraising for the advertising. Okay? If that means billboards, if that means, any type of activities, we need to have slogans. I want my 40 acres and a mule. Anything. Okay? We need to really seriously have conversations about slave reparations for ADOS, for American Descendants of Slaves. So I just want to share with that. Now I'm going to go ahead and also play another audio. I told you earlier, and I think it was in the last podcast, the other video, author his name is Ta-Nehisi Coates. Okay, he's from Baltimore. He's a Black author, and he wrote a book called The Case for Reparations, Ferguson and Beyond. That was back in 2014. So I'm going to go ahead and play the audio for that. Okay, just here.
The idea that, I would say, listen, I don't want any of my tax dollars going to any, widow or kid, from the Spanish American. It just sounds ridiculous. I only want to pay taxes for the things that I am directly responsible for. People would look at you like you're crazy. It is the very definition of a state. It's integral to the definition of a state that the state outlives its individual citizens. If it didn't, we wouldn't have, a President's Day. We wouldn't have people putting, we wouldn't have Memorial Day. We wouldn't have all of these sweets and traditions in which there would be no, reason to talk about American history at all. Because your history is only your personal history. What are you talking about American history? You didn't do that. You didn't do anything. What are you talking about? If you really want to take that approach, you know what I mean, then you don't really have an identity as an American at all. And so what people want is they want a la carte. They want to be able to claim the things that are good. And not have to claim the things that, don't necessarily credit them. They want to be able to, open that paycheck and never open the credit card bills. That's effectively what you're arguing for, as I call it in a piece of kind of a la carte citizenship. I get to pick, when I, am a citizen and when I am not. In a la carte patriotism, I get to pick when I love my country and when I don't. Imagine if I, said to my wife, baby, I'm only going to love you, when it immediately credits me. That would be ridiculous. That would be absolutely no species of, no specimen of love could live in that sort of way. And yet, when we talk about reparations, we get these sort of ridiculous arguments that don't really hold water in any other context, except when we're dealing with a group of people who we don't actually consider to be fully human.
Mm-hmm. Amen. So, I want to ask one last question, and then we're going to open up the floor for questions from folks. But we haven't talked much about the movement, right? The gains that we made over the course of the period from emancipation to the present came from folks disrupting, protesting, putting pressure on the status quo, a movement or movements really working for change. And I want to think a little bit about what prospects you see for a movement to really go beyond. I mean, yeah, we can all write to Congress and say adopt Congress's bill, but we need more than that. We need to really think about how to put pressure on the system for more systemic change. How do you see that happening? Do you see it as a possibility in this moment of history?
Well, there are two things. I'm a writer, and I'm not an activist. And
now listen to that. He got a little cowardly here, okay? And that's that kind of behavior that we cannot have anymore in our community because it's hurting us. He backed down. He's like, I'm not a civil rights activist. I'm not, I'm a writer, I mean, oftentimes if you write a book and you feel passionate about something, it might turn you into an activist. And so I really didn't like that piece right there, but I'm going to go ahead and let that play.
Anything at all wrong with activism? Obviously, it is not, and I obviously don't think so. But I really think it's really, really important for me to inhabit my role and to live in that place. Just like, I don't like ask for activists to go out and write 16,000 word, essays and, cover stories for the Atlantic. There's obviously a relationship between the two. But I think it's very, very important that, I stay where I am, maintain, my journalistic perspective, which is not objective, but, can be fair. Because oftentimes we find ourselves having to be, as journalists, to be critical of activists. Activists find themselves having to be critical of us in much the same way. And I think that tension, even when, we share a particular political perspective, is actually really, really, really good. If I had one particular conservative movement among many, in this country, it's that often that same distance, isn't really there. And I would say the same thing on the left when, journalists who are of the left lose that and become activists themselves. I think it actually affects their journalism and ultimately affects the movement in a really, really negative way. So, having said that, I think it's very, very important to understand that struggles are long. Any thing worth doing, generally, involves a long, long struggle, and oftentimes struggles, extend beyond our lifetime. Again, enslavement in this country lasted 250 years. I am sure that when the first Africans came here and changed in 1619, somebody understood that enslavement was wrong. And as enslavement became, a situation of basically color caste, I am sure that there were plenty of African Americans in this country, and I know, obviously we know, who protested and said, this is wrong. The vast majority of those African Americans did not live to see the fall of enslavement. And I think, people who are serious, people who are seriously committed, not just to reparations, to any cause, must, commit themselves, in the same manner their ancestors committed themselves. Frederick Douglass obviously believed in the equality, of all Americans. Frederick Douglass did not live to see that day. He never stopped fighting. Susan B. Anthony obviously, believed in the equality, of women and the right of women to vote. Susan B. Anthony did not live, to see the day when that happened. I think we should be very, very careful about claiming, in this particular moment, by shaping our goals by what can, survive a filibuster and what cannot. The definition of politics extends beyond the voting booth. And oftentimes it extends, beyond the individual lifetime. And I think people really, really have to be clear about that. Our struggles can't really be confined. If we really, really are committed, and if we really, really respect the people that came before us, cannot just simply be confined to our own lifetimes.
We're in it for the long game. I think that's for sure. And you sound even more like a historian than even your first-rate journalist colleagues, and that's great. Well, what I want to do right now...
All right, that's enough of that. So they go to a question and answering. The audience, you can go take a look at this video. It's on YouTube. The audience is a diverse audience. And they go and they ask, a lot of different questions and so on. So I want to go ahead and prepare for you guys now another... is... as I was telling you guys, and I might have said it in the last, was on Friday, I listened to Will Johnson. Will Johnson is an ultra Republican conservative, and he's got a show called Unite America First. And like I said, I don't believe in a lot of things that he says, but he does have some very interesting people that call in on his show. And so I want to share with you two callers. The first caller is a white female that called in to talk about how she wasn't going to pay for it.
If you ask for anything that's black, you got to say.
No, this is another one. Well, since I got this one here, why don't I go ahead and play it? This is a black man that calls in. It's a very good call, so just listen.
Minority, diversity, people of color, brown people, and all that kind of junk. That's one thing I don't like about Yvette Carville. See that breaking brown? it should have been okay if she'd have been Breaking Black, because I'd say that we are the newest people on the face of the earth. You know that?
Yeah. No, I agree.
And we are the,
I agree.
We're the only black people that come together in this world that we can go from New York to Washington State, and if it's blacks out there, we have in common. Our culture will be the same. You know what I'm talking about as far as the music, basically the food. If I left New York, went to California, right?
Oh, that's true. I mean, because here in California, you know, when I was living in Arkansas, I used to go down to the Sammy's Barbecue, to the soul food, and you come to California, and they got different shops here for soul food. I mean,
right.
You're right.
But when you go to Africa, I don't know if you have ever read the book of Chancellor Williams, Dr. Chancellor Williams. He was the president of Howard University. And he wrote the book about in 1970s about destruction of black civilization.
No, I haven't read it.
And whenever you read, well, they got the audio on this, a big book. But when you come to find out about, and I've always said, and it was just something you have a feeling like,
Again,
they say you and I will be in the same family, right?
White America
but
first.
That's the way it is. But I have black sisters, and that's the way we are, right?
This was a very good call.
And so, but in Africa, he wrote about there's 1,000 different languages in Africa. Now, Swahili is the language that speaks all over Africa, right? But the reason why they were taken over is because in his book, he wrote all those tribes, there's so many different tribes, and they kill each other. How can we ever be Pan-African? And what it was, that see, before ever a black ever came to North America, right? Do you know that the Arabs and the Muslims, they were been in the slave, but after Islam came in 639 AD, they will create these jihads, you know, and forced a lot of Africans into Islam. They went out and hunted our ancestors just like they were animals. The white man didn't go in and corral us and you know, like a lot of people want to portray it.
They're still,
and in fact, the black Africans sold us, huh?
They're still doing it today.
That's right. The Arabs been dealing in slaves and black slavery for 1,400 years.
Yep. Let's Daniel.
You know, the Western world.
Daniel. Let's do this.
This was too much for Will.
Because I really enjoy everything that you're saying. And I'd like to bring you on for a full hour, just like I did Alice. And we can lay all of this out. So if you would, do me a favor.
Hey, you know, yeah.
I was going to say.
You got my number there? I'll call you back.
Well, send me. I want you to do what I like for you to do is send me an email, because if you send me an email, my producer will get it and she will schedule a time for you to come on that will best work for you.
Oh, wow.
Are you able to do that?
Hey, you can call me anytime. I'm retired. You got my number?
Okay, yeah. Here, hold on one second.
I give you the house number. This is my cell, right?
Okay, yeah, don't say it on here, because you know might be someone on here that's listening don't need to be listening. So I have your number.
Okay.
I got your number.
Well,
you
got my cell number. You got it there. So anytime you want to, you call. I got T-Mobile. Sometimes when I'm down in Carolina, I go down there quite a bit, right?
Okay.
Because what I was wanting to talk about, what struck a nerve about that ADOS. See, that directly takes and exposes about our reparations. What Yvette Connell is talking about, we should get reparations. She doesn't know that from 1865, after we were free from the slavery, this is another one of the things what I want to talk about, is how the Republican was the only one that did any damn thing for blacks in this country.
Yes, that's true. That's true. And
the Republicans were, and see.
But let me ask you this. But see, you get a lot of people today. The Democrats are saying, well, the party switched.
No. The party didn't switch.
I know.
Hey, I got a book here from North Carolina. Do you know where? Who were the slave owners?
Democrats.
Okay. Who were the Confederacy?
Democrats.
Because when Jefferson Davis in 1860. December 1860, when they seceded from the Union, right?
Mm-hmm.
and they appointed Jefferson Davis the president of the Confederacy, right? He walked off the Senate floor. He was a senator from Mississippi and went to be the president of the Confederacy. Okay, if you want to take and when P.T.G. Beauregard fired on Sumter, South Carolina in December 1860, right? He's a Democrat. All of them were Democrats, right?
Yes.
When the Union kicked the butts of the Confederacy, right?
Mm-hmm.
And here's a lot of things. You ever heard of the Ironclad Oath?
Yes.
Okay, that was they were going to decapitate the Confederacy. They weren't going to allow them back. Anybody that participated in the Confederacy to secede from the Union, they couldn't participate in politics no more. That's what was called the Ironclad Oath. Mm. And guess what? Abraham Lincoln, I never had a favor for Abraham Lincoln because he was no different than Jefferson Davis, because he believed in 1858 when he had the Stephen Douglas when he was running for president, right? That blacks shouldn't be in charge or rule. We weren't equal to whites. We shouldn't marry whites and all that stuff. Then in 1871, when he addressed Congress, you know that Abraham Lincoln wanted us to take 39 years before we got full freedom. He wanted to do it piecemeal. And he even reached out to Liberia for us to go back to Africa and Haiti. You know that? It was the radical Republicans. I don't know if you heard of John Sherman, right? That was William Tecumseh's brother out of Ohio. They were staunch abolitionists. And they were radical because they wanted to decapitate the people that had participated in the secession from the Union, and not let them be in politics. And you know something, a misnomer is Reconstruction. What do you think about when you say Reconstruction?
Tell us.
Reconstruction, blacks don't know the history. It wasn't, the Republicans didn't set up Reconstruction. They set up what's called biracial rule. And you know what biracial rule was?
That's when you can't marry someone that was out of your race.
No. I'm saying biracial rule. You know, governing. Oh, that's what. Okay. This is what I'm talking about. They just say biracial rule. They were helping us once free from slavery, right? They took those states and was teaching us how to govern. That's Republican. And if you ever heard of carpetbaggers?
Yeah, I've heard of it.
Well, you notice always the Democrats talk bad about when we were growing up in the South. I'm from North Carolina, so how bad the carpetbaggers came down and stole all the money from all that stuff, right? But all that was about. They were down here to teach us how to govern. You know that?
Huh.
You never heard of, I tell you what, one day you got to talk. We have to talk a long time because this will be a good show for you.
Yes.
And I want you to bring you
look
up one thing.
All right.
And while you were doing this, I'm going to tell you something that's never come.
Okay. So for those people who do not think that that can't happen again, remember it was overturned by Andrew Johnson. Andrew Johnson became the president because Lincoln was assassinated. Okay, Abraham Lincoln. Okay, and so reparations were given. Again, we were granted 40 acres, a mule, and $100. Okay? Now, I think that we need to get equivalent to what they granted back at that time. Okay? And back at that time, 1865, that $100 would be something like $100,000 today. Recently, one of the representatives said $50,000, okay? People are throwing out numbers out there or whatever. I mean, even if it was 50,000, that's fine. What's more important here is not the money, but it's the land. Because the argument here is that we have been injured. as being American descendants of slaves. We've been injured. Not only did we go through slavery, we went through Jim Crow. We went through, we're still going through stuff. It's like we do not have the freedom of white Americans. We're not still free. Okay? The 13th Amendment. I'm going to show you the 13th Amendment. This is in our Constitution of the United States of America. Section 1, neither slavery nor involuntary servitude except as a punishment for crime whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. So, if you are a criminal, you don't have any rights. You are treated like you were a slave back at this time. And that's very important here. And this is what Kanye West was talking about recently. And it didn't come off so good because, he's good at music, but he's not as good at music as he is speaking, unfortunately. So it's the 13th Amendment in our Constitution that these people in America still continue till this day to oppress us with. Because what they've done after Jim Crow, after civil rights, I should say, 1964 with Martin Luther King, is they have criminalized black people all over this country. All over this country, we have been criminalized for who we are, for just being black in most cases. We're targeted. We know we've been racial profiled. We have black people getting killed. We are incarcerated at a larger number than any other group. And that is not by coincidence. It's all part of their plan. America has oppressed us, and it's time that we get our reparations. And we have to stay steadfast to this. We can't wobble. We've got to stay steadfast on this topic. And that's why I think it's very important that we in this country we have this discussion. Because at some point in time, America is going to have to give us our reparations. They're going to have to give us our reparations. Now, if it's not even in my lifetime, it will be hopefully in the lifetime of my children. So, I think it's just a bad situation. Now, okay, so I want to play another caller. Now, this is a white caller. She is also from Will Johnson. Again, his show is Unite America First. He is an ultra-Republican black conservative. He's got quite a bit of a following, and he's very much a part of these black Republicans that Trump right now is entertaining at the White House. In fact, he's supposed to be at the White House sometime this week, okay, Will Johnson, for some kind of dinner that they're having. So, there's quite a few of these young black Republican party like Candace Owens and so on, and these people, if they can get it done in the Republican Party, I don't care if they get it done in the Democratic Party. I don't care. To me, it has nothing. It has no bearing on where it's going to get done. Okay? If it gets done, I don't care. I don't care who gets it done. Just as long as it gets done. Okay. So, you can hear my computer talking, people sending me messages, so I'm sorry, I apologize for that. So, okay, I'm going to play this next call right here. This is the white woman.
Yeah. If you ask for anything that's black, you got to...
No, I'm sorry. Let me go back.
Yes.
I wanted to touch on reparations. I keep hearing about we need to give reparations. But listen, I heard somebody talking, and I don't remember who it was, but I think it was a black person the other day, just almost demanding reparations. I want to know if all these young people, and it seems like they do believe that once the reparations is going to be demanded of us, that they're going to get a pocket full of money, because it ain't going that way. This person said they was going to do housing and roads, and they're going to find a way to pocket that money, and citizens like y'all are not going to get nothing. But they're under the understanding that they're going to get a pocket full of money.
Well, see, the Democrats are pushing it in their heads. I mean, look at AC. What is it? AOC, where she's saying that you'll get paid even if you're unwilling to work.
That's
what you call spinning. Let
me just stop it there. Spinning the story. Okay. This is what I call negative affirmations. The negative spinning of and everything to come up with. And now, this is what I would say, Will, you're being an agent for white supremacy at this point. Because of the fact that he should have put this caller in check. If he is actually an American descendant of a slave, he doesn't look, I don't know if he is or not. I mean, he looks like he's mixed to me. All right. I'm going to share my screen with you so you can see. This is what he looks like.
They're pushing. I mean, it's crazy, you know. And when reparations first came about, so I was reading a book, and when reparations, and I didn't even know this, when reparations first came about, it was the Republicans that put it in place. So then that way, so black people can get a start, get a 40 acres and a mule, so they can get a start and become somebody and do something. Well, the Democrats found a way to take it from them. And Daniel, he alluded to it, talking about how, you know, different businesses would, you know, get X amount of money or get certain things, and then they just take it from them and put their name on it and make it look like it. It's the same thing all over again.
And that was for the slaves back in the day.
Exactly, not today.
Slaves now to get reparations.
That's what I'm saying. I'm not how would it sound for me? Yes.
I wanted to touch on reparations. I keep hearing about we need to give reparations.
Okay. So that was the caller. Her argument, and many people who want to argue against reparations, they're going to argue and say, why should the people today pay for reparations for something that happened before their... Because you're an American, okay? And I don't care if you're an immigrant and now you became an American. If you're American, this is something, a mistake that America made, and America's never paid for it. And there are other groups that have gotten reparations. You have the Japanese that got $20,000 a piece for the internment camps that they were put into in the 1940s. You even heard a video where you said, where I played the audio for Barbara Ratcliffe, attorney Barbara Ratcliffe, okay, a sister out of LA, who went and she explained, you heard her say that Bill Clinton in 2000 helped the white Jews even get reparations. From Germany, even America put in $29 million for that, for the role that they played in that. And Native American Indians, of course, they stole this land, and that's a whole nother subject about who the real Native American Indians are. I know I have ancestry from the Seminoles, okay? My great-grandfather was a full blood from Oklahoma. So who the real ones were, that money, the people even now in those treaties that were passed for the Native Americans that this country gave money to, that's a whole nother discussion, and I'm going to have a podcast on that as well. talking about the ADOS Act and the $5 Indians that are not really the natives, who are overseeing even casinos and all of the big businesses on Indian treaty land that was given. And it was given rightfully so, but the people that are running it now are not the original people. The tribes have kicked off the original people for the last 100 years. The last 100 years, okay? And that's a whole nother podcast, as I said. So, her argument is, who's going to pay for that? You're going to pay for it because you're an American. You love America. America was built off of the wealth of the labor. You built your wealth off of the labor of slaves, America. Companies like J.P. Morgan, Fleet, Jim Beam, Wells Fargo acquired Wachovia, Aetna, Cigna, Levi Strauss, and the list goes on. Bank of America. These businesses are wealthy businesses that have not paid. This country owes us. We laid the railroad tracks so that cotton that we picked would travel across this country. We built the wealth of this country. And we have not been paid for that. I don't care if we're not the same people. We have suffered. The children of slaves have suffered, America. We have suffered. So I get very passionate about this. It is such a serious topic that I don't want to see anybody, if you're a black YouTuber or anybody out there, I do not want to see you degrade this. If you are an ADOS, if you are an American descendant of a slave and you don't feel like you need to get your reparations, sit down, shut up, and just be quiet. Because this movement is going to happen. And we are not. We've been picking at it, but the solution is much bigger than this, than just picking at it. We cannot pick at this subject anymore. We cannot. And as I said, what we need now are black lobbyists, black attorneys. We need comprehensive marketing and advertising, and we need fundraising. Okay? So, white people don't want to pay for something that their ancestors did to black slaves, even though they have benefit from the wealth. These white people have benefit. These are the families of these bankers. These are the families of these plantation holders. These are the people that held the property. You people, if you are American, you are white, and you are here, you have benefited from slavery. And all we're saying is it's time to pay us. And I don't think $100,000 is a lot of money at all when you can go spend billions of dollars to build a wall. Okay? The other thing is, the other argument that they have is the immigration, because there's a lot of immigrants in America and they don't want to pay, but you're an American. If you have been sworn in as an American citizen, you are an American, you need to pay. You need to pay as well, because you are also taking advantage of what black people have built already in this country. My people have suffered. And this is to all the immigrants. We have suffered, and we built this country. You would not be over here if it wasn't for what the contributions have been from blacks, the original blacks in this country, the descendants of slaves, my people. So, positive propaganda only. Black people have to believe it can happen. You've got to stop negative affirmations about people getting reparations. As I said, if you don't have anything good to say, then don't say it at all, especially in public. Enemies are always watching. They're always looking to infiltrate movements. Okay? We have to trust each other, think positively, work together for the group collectively. We've got to work together for the good of the group. What I've heard all weekend from other black YouTubers is nothing but bickering, arguing. Oh, it's not going to work. Well, get it together. Seriously, get it together. Because it can happen. You've got to believe. You got to be positive. You can't have that negativity. Okay? We can no longer be afraid to have a successful, to have this movement and be successful people. We can have a successful movement here. And we can fund this, and we can work, and we can do this all in our communities, people. We don't have to have some outsiders outside of our community come inside and get the help of them. Now, we can consult, but we need to be in charge. Okay? I don't care how it gets done, as long as it gets done. So, one thing that we're afraid to do now is we're afraid to talk about race issues. Okay, I know so many black people that are afraid to talk about race. It's crazy. I don't understand why you're afraid to talk about race. You're black? Express yourself. We can talk about race. This country has a bad history on race relations. We know this. We know that we've been oppressed. We need to talk about it. Never let anyone forget. I remember when Snoop Dogg, I guess, a year or so ago, he got mad when we were talking about slavery, or something came out on slavery, and he comes out and people, you hear these people, these kind of people who say they don't want to talk about slavery, they're full of it. You need to talk about slavery all the time. You need to let your children know. In fact, that is one thing I'm going to get to it. What things that you need to do right now is to be talking to your children. You need to research your ancestry if you are ADOS. You need to get all the documents and receipts together if you are ADOS. I'm talking about pictures, any type of artifacts, anything. Okay? And so privately held corporations like JP Morgan Chase and Fleet, as I said before, they owe us. Now, President Trump, he asked black people, what do we have to lose? And that's what I ask you all. What do you have to lose? Don't be afraid. Black people, we must be unapologetic, okay, about these issues. We have to have these conversations, as I was saying. We have to have them. So, with that being said, I'm going to end on that note because it's now been almost 2.5 hours since I started this stream. And I want you guys to join this YouTube channel if you haven't subscribed. Okay? If you want to contact me, there's my telephone number. There's our Facebook, which is bobrewards.club. And YouTube, again, if you're looking at this on YouTube, subscribe if you're not already subscribed. Twitter is the Bob Program. Bob stands for Black-Owned Businesses. And then we've got the Bob Rewards Club, okay? So, thank you very much. Invest in your Black community. And I will see you guys in the next podcast.